Hello, my name is Brian, and I'm one of the attorneys here at Fidelity Law. One of the most frequent concerns that my clients express to me is their desire to maintain as much of their property as possible through their bankruptcy proceeding. This is a very natural desire, and with some careful planning, you can make sure to maximize your assets legally and ethically. One way to do this is called exemption planning. The general rule in a Chapter 7 bankruptcy is that the trustee can sell any assets of the bankruptcy estate and use those proceeds to pay your creditors. However, there's a whole list of different types of property which are exempt from this rule. That means for exempt property, the trustee can't sell the property, but instead the property is returned to you after the bankruptcy is discharged. So the immediate question becomes, is there a way to convert non-exempt property into exempt property prior to the filing of the bankruptcy? And the answer is yes. Prior to the filing of a bankruptcy, you own all of your property, and you're free to sell, buy, transfer, or convert it as you see fit. The one major restriction to this is that you're not permitted to make any such conversion with the intent to hinder, delay, or defraud your creditors. So exemption planning is okay as long as it's not done with the intent to hinder, delay, or defraud. Now, this might seem a little strange because one could say that anytime you convert non-exempt assets into exempt assets, it's done with the intent of keeping those assets. So in essence, you're doing it to hinder your creditors. But the courts don't generally look at it that way. Most courts have come down on this issue by saying that the test of whether a conversion is improper really comes down to how greedy the debtor is in the action. So it's okay to convert some of your property, but just not too much. This is determined on a case-by-case basis, so it's a little difficult to predict how a court may view this. The new laws passed in 2005 did give a few new sections which do shed some light on the question of exemption planning. Two of these new rules deal with the homestead exemption, which grants a debtor an exemption for certain amounts of equity in their home and prevents a trustee from seizing and selling a home which has less than the statutory amount of equity. The first rule is found in Section 522(o), and this section says that no matter how much equity is allowed under a particular state's exemption, you need to deduct the exemption value of the property that was sold and invested in the home for a 10-year period prior to the filing. So this new rule can make it very hard to shelter non-exempt property in your home under the homestead exemption. The second rule comes in 522(p), which limits the homestead exemption even if there's no intent to hinder, delay, or defraud. This rule says that the debtor can't exempt any amount of interest that was acquired during the roughly 1,000-day period prior to the filing that exceeds $125,000. This may be a little bit confusing, but it essentially acts as a cap on the amount that the homestead exemption can be increased preceding a bankruptcy. Bottom line is that exemptions are an extremely important part of the bankruptcy process. Properly managed, the exemptions can make all the difference in your ability to maintain your assets. So if you're considering a bankruptcy, please make sure to consult with a qualified attorney to discuss these rules and how to best apply them in your individual case. Good luck and have a great day.